So my goal in this presentation is twofold. So first, I want to start off with this question of what's happening at the FDA, looking at specific examples of recent developments, as well as exploring it at a higher level of generality. And then second, and more importantly, I want to talk about why it matters. And when I do that, I'll do it in two senses. One, in terms of what are the major theories underlying FDA's legal authority: consumer protection, efficient product review, information generation, and how are they impacted by these changes at the agency? And then a second, in terms of how other actors, insurance companies, international pharmaceutical regulators, and civil society are being impacted by these changes. The broader paper from which this talk is drawn explores other aspects of these issues, which I'm looking forward to talking about maybe in the Q&A, but I'll focus my remarks on these topics, both in the interest of time and to minimize some overlaps between our talks on this panel. So first, what's happening? We can organize the current goings-on at FDA into a number of categories, and then examine each of those categories as they relate to FDA's ability to perform its core functions. So first, the decimation of state capacity. So back in April was the most recent large-scale reduction in force at FDA, to which Commissioner Califf responded with this LinkedIn post. He says, "The FDA as we've known it is finished, with most of the leaders with institutional knowledge and a deep understanding of product development and safety no longer employed. This comes in a much broader context of the firing of probationary employees, voluntary buyouts, and other developments." I'll note in response to Professor Robertson's presentation that there was a significant reduction in force to the FDA office that reviews advertising. The general concern regarding large-scale firings like these is that they may limit the agency's ability to perform its core functions. And depending on how the firings are carried out, you could imagine that happening via a range of mechanisms. So one is there may simply be too few people to perform the required work, such that the work is either delayed or foregone entirely. FDA notified one manufacturer that the agency could not meet its statutory deadline to make a decision on that manufacturer's new drug application, citing, quote, heavy workload and limited resources. These procedural consequences can have substantive impacts. Some of these substantive impacts can harm patients in the short term, particularly those whose conditions may worsen while waiting for FDA to act on an approval decision it has delayed. But others may harm patients through in the longer term by reducing the quality of the data that are generated through the approval process. So, as one agency reviewer put it in an interview with Stat News, quote, there are going to be situations where we don't have the expertise on hand to review a file, and so questions will not be asked. In the post-market, these issues are going to emerge. A second thing that's happening is increased political control over the review process, rather than allowing these decisions to be made by career scientists and product reviewers. So historically, presidents and FDA commissioners of both parties have advanced agency-wide policy goals, and that includes efforts to speed certain types of products to market. But almost without exception, they've deferred to career scientific and statistical staff regarding determinations about whether individual products meet the relevant thresholds for approval. And media reports have identified at least four, possibly more, depending on how you count them, examples where political appointees have directed agency staff to reach particular decisions about specific product applications, three of which, or at least three of which, involve vaccines, with the commissioner stating publicly that there are likely to be more such examples. In these scenarios, there may or may not be robust evidence available to support either the approval or the disapproval, depending on the context. Political interventions to approve a product may have different consequences than political interventions to reject a product, although either may reduce public confidence in FDA. For drug manufacturers, this is also likely to increase existing regulatory uncertainty. A change in the approval standard may reduce public confidence in a way that negatively impacts manufacturers, but that might do so across firms writ large. But politicizing the process at an individual product review level can create greater risks for manufacturers. A third development where we have maybe somewhat less evidence of how much it's occurring, but we've heard a lot of noise about this possibly occurring, is this idea or this question of what FDA approval standards should be. And there are a number of actors who are currently in the administration who have the view that FDA should approve drugs upon a showing of safety only and to let patients use them at that point before they demonstrate efficacy. So the first quote here, admittedly, it's some years ago, is from Jim O'Neill. He's currently the acting director of the CDC, but also, I believe, the deputy secretary of HHS. He was Senate confirmed to that position. And then the second quote here is from Matthew Zorn, who I believe is currently the deputy general counsel or a deputy general counsel at HHS Office of the General Counsel. And so they say things like, right, I think there's a really good case that we shouldn't be testing for efficacy, or that can be done post-approval. The underlying idea here is to envision a very different model of FDA approval on the basis of a very different type of evidence or quantum of evidence than we have today. The magnitude of the effect on the development of information about the safety and efficacy of the relevant products would likely depend on how this is pursued and how broadly this is pursued. So now I want to talk about why it matters, linking each of these three developments to the major theories underlying FDA regulation and the ways in which each of these scenarios threatens to undermine the goals of these theories. So one is the modern FDA exists in its current form for a reason, right? One of them, maybe the first one, is consumer protection. So for those who are, as Professor Robertson put it, those of us who are nerds, right? We think about Dan Carpenter's seminal book, Reputation and Power, as embodying many of these basic ideas, right? The FDA exists to protect patients from unsafe or ineffective drugs. And we often talk about drugs as paradigmatic examples of credence goods, right? Products whose utility and quality consumers can have difficulty assessing even after consumption. If the market can't sort it out, if there's associated information failures, information asymmetries between manufacturers and patients, that can justify consumer protecting regulation of this type, especially when it's information generating, as I'll discuss in a moment. And this is related to key historical developments in the agency's history, where its regulatory authorities have come in the wake of key public health tragedies. And so after the 1962 amendments to the FDCA, a manufacturer seeking to bring a new prescription drug to market has to demonstrate to FDA that the product is both safe and effective for its intended use before receiving marketing authorization, giving FDA's modern gatekeeping function. But second, we also care about FDA's review of products in an efficient manner. Congress has consistently instructed FDA to be mindful of this, both because of the needs of patients in accessing these products and the needs of manufacturers for predictability in regulation. Some of these efforts have applied widely across the agency's review of all types of new drugs. So, for example, the speed of the review process is closely related to the role that user fees have played in the funding structure of the agency since 1992. But in other cases, this is more localized. So, for example, FDA now has 4 expedited review pathways for which manufacturers may apply for products which are intended to treat serious or life-threatening conditions. This theory invites a discussion of trade-offs somewhat more explicitly, right? Regulators can choose to speed a new drug to market or collect additional information about the safety and efficacy of that product. Choosing to expedite marketing approval for a product, particularly if that choice decreases the amount of information that's available to the agency at the time of its approval decision, might decrease the accuracy of the agency's decision-making and lead to more errors, but by definition, it provides earlier access to patients. Third, information generation. And this theory is most closely associated with law professor Becky Eisenberg. And her main point is that FDA's legal authorities enable the agency to require manufacturers to produce information about the safety and efficacy of potential new drugs prior to their market entry. And in the absence of FDA requiring such information, private firms are not motivated to perform this function on their own, because manufacturers otherwise would struggle to appropriate the value of otherwise non-excludable information goods, such as the results of a clinical trial, and therefore they'd be disinclined to generate it. FDA regulation serves this important information generating function. One important extension of this argument that's more recently been made by Professor Holly Fernandez Lynch is that this information produced through the clinical trials process can be used not only by FDA, but also by patients and clinicians in guiding treatment decisions in a way that's autonomy enhancing. So, some libertarian critics of FDA argue that the agency constrains patient choices, but patients and clinicians need information to make evidence based choices. And Professor Lynch argues that approving a drug without the benefit of such information is not, in fact, autonomy enhancing. Each of the three situations that I've talked about, state capacity, politicization, the approval standard, has the potential to undermine these key theories supporting FDA regulation. Each situation can harm the agency's ability to protect consumers, primarily by increasing the agency's rate of errors in the product approval process. An agency with limited staff capacity may be more likely to erroneously approve or reject a product, harming patients who may take an unsafe, ineffective drug or who are denied access to a safe, effective product. The same is true for an agency attempting to make such decisions on the basis of much less information in something like a safety only approval situation, or an agency making such decisions on the basis of politics. To be sure, the magnitude of the increase in the error rate might differ depending on which situation and how aggressively it's pursued, but it's likely to be impacted. The ability of the agency to generate information about the safety and efficacy of regulated products is also likely to be impacted, especially by large-scale changes in the approval standard, maybe less so by some of these other developments, right? So by definition, decisions to approve products on the basis of less information than is currently developed may impact the gathering of that information. These scenarios might differ in their impact on the speed and efficiency of the review process. So most obviously, it's highly likely that a large-scale change in the approval standard would bring products to market more quickly. It's less clear this is true of the other two scenarios. Either one of those could conceivably lengthen the approval process relative to its baseline. So if the agency has fewer staff available to perform its core functions, a wide range of steps in the process, culminating in, but not limited to, the ultimate approval decision might be delayed compared to a situation where the agency was more fully staffed. And if the agency is being driven by political motivations, those motivations could either delay the process if political appointees are seeking to intervene in particular reviews, or could leave its length sort of unaffected. And then these types of errors are likely to be experienced somewhat differently by patients as well. I want to take a minute to note briefly that these potential impacts to the prescription drug approval process wouldn't be limited to FDA. So FDA exists within this broader institutional context, and it's a broader context that's changed dramatically since the passage of the 1962 amendments. And the choices that the agency makes, including choices to change its own approval processes, they have consequences for other key healthcare stakeholders. This broader institutional context is a relatively new construct, growing and evolving substantially since FDA was given the authority to regulate prescription drugs for safety and efficacy since the 1960s. FDA's embeddedness within this broader institutional context can exacerbate some of the challenges that would occur by moving to a different type of review process. So, for example, FDA is not the world's only pharmaceutical regulator. If FDA were no longer to make the same kinds of decisions about the safety and efficacy of new prescription drugs, or did so under conditions that called into question those decisions' reliability, other countries' pharmaceutical regulators could continue, in theory, to make their own choices about whether or not to approve particular drugs. Those choices, depending on the generation of information about the safety and efficacy of a drug candidate, could then serve as an important informational signal, if not legal signal, for US-based stakeholders, including insurers and nonprofit entities, about the quality of the drug product. There are limits to this, both in terms of scope and ability of US-based stakeholders to actually use that information, but it's important to note. One feature here is that for roughly 15 to 20 years, FDA has usually been the first mover internationally in approving a lot of these products. You could imagine that changing. You could imagine a whole range of actors who currently reference FDA decisions changing to reference EMA or other decisions as well. Second, although FDA approval is a necessary condition for enabling patients to access new therapies, it's generally not sufficient. Patients also need insurance that covers the relevant new products, and the high cost of prescription drugs often puts them out of reach for patients without insurance coverage. In prior work, I've written about the ways insurers are sometimes required by law to cover FDA approved drugs, particularly public insurers like Medicare and Medicaid. And this linkage creates significant consequences for insurers in any evolving type of FDA approval situation. So, if FDA approval, the meaning of that changes and is no longer, at least in some cases, a reliable signal of the safety and efficacy of the resulting products, it matters whether insurers are still required to cover any product which is nominally FDA approved, even if the underlying substantive meaning of that decision has changed. Third, and finally, we can think about the role of nonprofit organizations or other expert bodies. These bodies would not likely be able to compensate for many of these agencies' core functions, but may be able to serve as additional reservoirs of public trust and sources of expertise. One set of examples is vaccines, where expert bodies are attempting to act to reestablish public trust in vaccines and provide additional sources of expert information for patients and clinicians. So the American Academy of Pediatrics announced that they will no longer participate in ACIP meetings as the new changes in AAP's view render the ACIP meetings, quote, politicized at the expense of children's health and no longer a credible process. Instead, AAP will continue to publish their own vaccine recommendations as they have done for 95 years, which is longer than ACIP has existed. So there's a whole lot of things that are going on. There's many intersections between this project or this work and the work that Professor Robertson has discussed. I'm looking forward to discussing in the Q&A.